Hey everyone, welcome to another podcast. We're here giving you great updates about immigration news, policies, law, and all the good stuff helping you reach your American dream. And today we are thrilled to have a very special guest, Judge Sandy Hom. I've appeared before him before, and now he's with our team at Alexander Law Firm. We're so grateful to have you, Judge Hom, and thank you for sharing your experience with us.
Well, I'm glad to be here. Actually, I'm glad to be on the team. It's been an exciting adventure for me, going from behind the bench to in front of the bench. So I thank you for that. I've found this experience to be very exciting in terms of advocating on behalf of certainly the most vulnerable people that are here in the United States, and particularly with the migrant problem that's happening now on the southern border and now in New York, given that many of them are making their way up here as a result of I would say, political edicts from certain states that have said that they're going to send their migrants to New York City. But being a sanctuary city and the work that the mayor is doing here, it's been reported that there is over 70,000 migrants that are being helped here in New York City.
Outstanding.
And that hopefully the mayor can get the cooperation of the Biden administration to help in that regard. So yes, it's been challenging on the asylum front. I have also, on behalf of the firm, advised the American Red Cross, which is starting a program to help these migrants in terms of asylum filing, to get them, on the way with regard to their applications and hopefully employment authorization so they can begin working and contributing. I think it'll be an exciting endeavor, and working with the American Red Cross and other law firms, I think it'll be a very, very important program that will help and assist the migrants that are in the New York City area. So
always happy to make an impact in any way we can, and thank you for your help with that.
Yeah, no, thank you for allowing me to do that to that extent. It's as I say, it'll be an exciting endeavor for a lot of the immigration advocates who are volunteering. It's strictly volunteer, and I figure with my 30 years of background in service as an immigration judge, I should be able to provide some assistance.
Tell the viewers a little bit about that. Describe, your time on the bench, and then how did that lead, your landing with us and helping our
well, it is a little story that goes with it. I was in private practice at the time with my wife, and when I got the call to be selected as an immigration judge, it was on April 1st. So it was at that time, Judge Pullen, who had called me, and when he says, we're offering you the position of immigration judge in the New York City court, and I asked him, I says, is this an April Fool's joke or is this for real? And he says, no, it's for real. So he says, talk to your wife and let me know. And I did have that conversation with her, and she says, listen, try it, because if you don't take it, they're not going to offer you the job again, but if you like it, then you can stay. And then so I stayed for 30 years, recognized service, and I've enjoyed every moment of it. I've learned a lot, and I've not only learned in terms of the law, but I've learned the immigration asylum practice. I've been able to meet many kind attorneys that were in the field, especially yourself, in terms of representing asylum seekers. And I've got to expand my knowledge, not only in the asylum field, but in every facet of immigration law and procedure, and also naturalization. As I say to my friends, there's probably no issue that I haven't seen that in my 30 years of service. So I'm grateful for that experience.
And I'm happy we kept in touch. That's just the way the stars aligned. Yeah.
Well, yeah. In terms of coming on and joining Alexander Law PC, I was fortunate to have the opportunity to talk to Felipe. And as things turned out, I was available, and his firm was in need of some expert representation with regard to the law and procedure in asylum. So here I am. And as I say, thank you for that opportunity. And I hope to make an impact in terms of the clients that are here, as well as in terms of the firm's reputation.
Absolutely. We're honored. Thank you so much. So let's have some fun. Let's jump into it. So folks, we've made videos and we've informed folks about asylum. But if you're watching the video, this video for the first time, you haven't seen other videos about asylum, Judge, give us a quick primer on asylum. And then today, the main objective is we're going to talk about a 1-year rule to asylum.
Yeah. Well, asylum is just one facet of the immigration nationality law. And how it came about, it's an interesting bit of history. There was a Russian sailor who was in the North Atlantic on a fishing trawler, and he had jumped ship when there was a U.S. cruiser or destroyer boat nearby, and he swam over and he asked the captain for refugee status. He says he asked for sanctuary, actually, and Mr. Stevic was kept on the boat. The boat captain called in its chain of authority, called its superiors. They checked with the Department of State, and unfortunately, they put the man on who was asking for sanctuary or refugee status. They put him back on the boat under the argument that it was the international waters. He was a sailor on that boat, and he should be returned back to that boat, as insisted by the other boat captain. As it turned out, that boat was a spy ship. It was disguised as a fishing trawler, and it was off the North Atlantic, spying on submarine traffic and activity from the United States, going toward the north, through the North Atlantic to areas in the Bering, well, not the Bering Sea, but on the European side. But poor Mr. Stevic was returned back to the boat, and then he was immediately sent to a gulag. And these are not nice facilities. They're facilities in which hard labor, and they're mostly in rough areas, and this one was particularly in Siberia. And he was sentenced to that gulag for a long period of time. As it turned out, historically, in his line of ancestry, there was a U.S. citizen, I think it was great-grandmother or grandmother, that had returned back to Russia. And in his line of ancestry, he could claim that relationship. And as it turned out, he was able to convince the Department of State and the United States government to be returned back to the United States on his claim of sanctuary. Because of that, and because of that seeming confusion, the immigration law was written to provide for asylum relief. As it's written in the Immigration Nationality Act, anybody who claims to be persecuted as a result of the 5 protected grounds that are in Section 208 of the Act would be entitled to asylum. And that's what we have today. Now, that has turned into a complete body of law, both case law and regulations, and the Act itself has been expanded to include various forms of asylum relief. One example is the inclusion of the family planning policy in China. It was deemed to be, yes, that was deemed to be a ground for asylum when people were forced by the government to adhere to a family planning policy that they did not subscribe to. So that was an expansion of that. And then there's the Chinese Student Protection Act, in which the students at Tiananmen Square were demonstrating for pro-democracy issues. And when they were repressed by the government, the U.S. government wrote into the Immigration and Nationality Act that these individuals would be granted relief in the form of asylum to come to the United States and be safe. So, yes, asylum has expanded from the time Mr. Stevick jumped into the North Atlantic and swam to that U.S. destroyer. But
so basically, what does one, and again, the topic of the video is the 1-year rule, but right. Basically, what does one have to prove in order to get asylum? And obviously, each of the elements we speak an hour on. Yeah,
that's a whole subject for law school, asylum law and procedure. So it's a very expansive product, but topic. But there's 5 protected grounds in which if a person feels that they have been persecuted or will be persecuted or has a well-founded fear of persecution based upon those 5 protected grounds, they can seek relief from removal or affirmative relief to remain here in the United States and create a pathway to citizenship as a result of that. If you're granted refugee or asylum status, after 1 year, you can apply for permanent residence, and then thereafter, you can apply for U.S. citizenship. The difference between refugee and asylum is a refugee is determined to be that outside the United States. For instance, the American Red Cross or other relief agencies may set up refugee camps and determine that what countries would accept refugees, would make a determination whether a person qualifies for that status or not, and then send them to that particular country. Asylum is somebody who's here in the United States or seeks to come to the United States, is at the border, seeks to come to the United States to apply for relief, and when they're granted that relief, they're considered an asylee, or someone who's requesting asylum in the United States. So that's the difference between refugee and asylum. But essentially, the criteria and the process is generally the same, except the refugee must go through the process abroad, whereas the asylee or the asylum applicant must go through the process here in the United States. And we're talking about primarily the process in the United States. It's very detailed, both in the Act and in the regulations. And there are certain criteria that have come about as a result of the asylum. As I say, it's been expanding and continues to expand, right? It continues to expand. And one of the expansions to the original 208 Act was the limitation on filing for asylum that's written into the Act itself. And that limitation is a person or an applicant must file within 1 year from the date of their arrival.
Okay. So was it always like that, or do you remember when that changed?
No, there was no 1 year limitation on that. In fact, when I sat on the bench in my early years, I saw applications that may have been filed 10 years after the person came to the United States.
Wow.
And that they remained underground, so to say. And then when they were apprehended, either by the police or by the immigration authorities, and brought to the immigration court, they asserted a claim of asylum. The 1-year issue was to do two things. One, to prevent this type of asylum request that comes many years after the events that give rise to the claim. And two, was to begin to uncover those individuals that were in the United States and that wanted asylum to come forward. So the act was written to require that any asylum applicant file their application within 1 year from the date of their arrival, and that was effective by a certain date written in the act. The application must be filed within 1 year from the date of arrival. And how's that 1 year calculated? It's the anniversary of the date of their arrival. So it's essentially a year and a day, or 1 year not counting the day that you arrived. So
the day you arrived doesn't count. Right.
Yeah, doesn't count. It's the anniversary date of your arrival.
And it's your last arrival, right? If you've come to the U.S. before, yeah, it's your last arrival.
It's your last arrival. So if you've come before and left and have come back, it's when your last arrival. And there is a whole body of law as to when somebody has departed the United States and when somebody has last arrived in the United States. But I won't get into that. We're just dealing with the basics of the 1 year issue. So who makes this determination of the 1 year? Only the asylum officer, the immigration judge, or the board members on the Board of Appeals. Those are the only three bodies that can determine the 1 year issue. Nobody else. So there is a question as to how that's supposed to come about. The language doesn't say shall determine, it says will determine. So the big question is, how is that supposed to come about? If it's not mandatory under shall, how does the let's say the immigration judge will determine? Is he supposed to do it at a particular time in the proceedings? Is he supposed to do it before the proceedings, sort of in the form of pretrial determination on limitation? Like in many civil matters, they talk about jurisdictional issues, whether the court has personal jurisdiction of the individual, or can it be part of the asylum application itself? It doesn't quite say. And there is one case that I recall, a precedent case, that talks about the requirement of the court to make that determination prior to the merits of the case. But in general, most of the circuits which haven't spoke about on this particular issue, they don't seem to be bothered by the fact that that the issue may be determined during the merits of the case itself, during the body of the merits of the case. So
that's really when you gather the facts, you might need to make a determination of whether an exception might apply, et cetera.
Right. Well, I think in best practice, if it's not apparent on the face of the application, the government generally speaks up and says, we think there's a 1 year issue on this. Then the burden is on the applicant to show that they either file within the 1 year period or that they fall within one of the exceptions. Okay. So, so let's talk about that. Now, it does say 1 year from the date they arrived, and it did set in the statute a particular time when that would begin. There is an interesting portion of that provision that talks about the Northern Mariana Islands, which is a territory of the United States, and as a result of the Second World War, that became part of the U.S. territories.
Or Saipan, as many people know, right?
Right.
Saipan, yeah.
They say that the 1 year period begins starting in January of 2030. So they gave them an extended period of time in terms of the asylum filing. But there's, as I say, there's not that many in the Northern Mariana Islands. But the provision also wrote in there, you say to yourself, well, if that's the case and I'm barred by the 1 year now, can I send my client to the Northern Mariana Islands to file an asylum application because it would be before 2030? And the provision writes, it does not apply to anybody who travels there from any of the U.S. states after November 28th of 2009. So you can't get around the 1 year issue by going to the Mariana Islands to do that. All right, so it's kind of clear when the 1 year starts. Yeah.
Yes.
1 year after the arrival on the anniversary date.
But things happen, right?
Yes,
Things always
do
happen.
happen. Well, not only that they happen, but the framers of the regulations understood that there are exceptions.
That's nice.
Yes. So the first one is changed circumstances, and this is changed circumstances in different arenas. One is changed circumstances in the conditions of the applicant's home country. For instance, let's say, particularly in the African nations where tribes can become political and they take over the political governance of a particular African nation. And it is known that in taking it over, that they would persecute different tribe members or different ethnic groups in that home country simply because of who they are. So if that happens, that gives rise to an asylum claim by the persecuted tribe, and they can make a request for it. An example also of changed circumstances is you may have a fear of persecution as a result of let's say your Christian practices in China, and you leave, but you're not quite, you leave before there's any attempts to persecute you. So you're leaving because of the safety factor that you think that you will be, but you don't have any concrete evidence to show that. But where there's similarly situated individuals as you, who is a Christian in your home country, do get arrested, do get persecuted, do get tortured as a result of their religious beliefs, that gives rise to a changed circumstance because now the government's enforcing that persecutory ban. So that can give rise to a claim, even if you're here in the United States. Or the applicant's circumstances materially change here in the United States if you're here. For instance, you become a newborn Christian, and in your home country, depending on the type of Christianity that you practice, may be offensive to the government's form of supported Christianity in their home country. Examples are Coptic Christians, Christians that practice Christianity versus the Chinese government, which says it's a superstition and is considered a cult, and they persecute individuals as a result of that. So that could be a material change where in your particular community, it becomes a ban to practice that religion, and they arrest people and they imprison them as a result of their religious beliefs. That can give rise to changed circumstances as well.
In practical terms, so we're talking about both changed circumstance, whether in somebody's country or whether as far as their personal life in the United States. So the example you gave, let's say I'm from whatever country, Africa, South America, etc., and I am a big supporter of regime A, and then regime B takes over, and I've been here for 2 years. For whatever reason, I never applied for anything. I wasn't afraid and I just never applied for any immigration benefits. Maybe I have a non-immigrant visa, maybe I don't. But then when regime B comes around and wins the election, I was a fervent supporter of regime A on social media, and even back when I was there. With that, could I argue a changed circumstance based on country conditions?
On that alone, no. But if you can show when the new regime comes in, they begin persecuting people from the same tribe or group or political association that you belonged to before, then that would be a material change. It happens in India to a large extent, or in
Haiti, we've had several cases.
Yeah,
Haiti,
Sunnis versus the other Muslim group.
And we're getting more from Brazil now.
Okay.
Yeah, there was a contentious election there. A very far right candidate lost to very far left, and the far left is actually arresting people who had opposed them before. So it's been interesting.
Would that be sufficient? The arrest itself? It can be if the arrest is purely based on political reasons. Then it's political opinion. Right?
Yeah.
Okay. So the other circumstance that where there's been material change that can give rise to a new asylum application that you hear is if there's a change in the law. And the one example that I can think of offhand is you're talking about female genital mutilation.
Mm-hmm.
The law and the case law changed with respect to that particular issue, and that became a basis for relief under asylum. So
it's good to tune in to podcasts like this or information
absolutely.
from attorneys, because hey, when matter of Kasinga came down or whatever, oh my goodness, all of a sudden I'm eligible for this relief, whereas before we didn't really know. Can we go back into the personal circumstance one a little bit? So you mentioned, for example, if I'm from whichever country and I don't subscribe to a particular religious faith, or I don't openly do it at least, and I come here and I become really involved with the religion that to some extent is persecuted in my country. Can you guide us through that a little bit?
Yeah, in that type of situation, as I say, the burden's on you to show that you fall within that exception. So that exception is if you've been here, say, 2 years after your arrival and you never applied for asylum, if you discover that your newfound Christianity that you've adopted while you're here in the United States has become a ban in your home country, and as a result of that ban, the government is mistreating or imprisoning people as a result of their religious affiliation, that can give rise to an asylum application. Excuse me.
Yeah.
An asylum application, even though it's been more than 1 year after your arrival. So
we have a lot of clients from China who come here, and some of them, exceed 1 year of being here because they were exploring their religion, and it just didn't happen before the 1 year, but then they really genuinely become Christians, for example. How do you see cases like that, and how what can the client argue to see that he's eligible for that 1 year exception?
Yeah, as I say, the burden is on the applicant to show that they fall within the exception, and if you can support your claim by showing either adverse circumstances in your particular community, news reports or topical reports showing that members of your faith are being persecuted in their home country, that would be supportive. People who are similarly situated than you, in other words, they also are a member of the same faith and are being mistreated and persecuted in their home country because of their affiliation with that faith, that can give rise to an asylum application, even though you've been here more than the 1 year period. Now, the question is when you're supposed to file that application. And the statute talks about what is reasonable. a reasonable period of time. So the big question is, how long should you wait before you file an application of that nature? And I would suggest once it's discovered that you would be entitled to the changed circumstances to file an asylum application, you should do so as soon as possible. Don't wait. It does not give you an additional 1 year after your discovery of this. It gives you a reasonable period of time, and the reasonable period of time is based upon the circumstances in your case. So
this is very important, very
right.
important, guys. So you don't have, whatever triggers that change circumstance. So let's say in a Christian case, we usually argue that it's the baptism that triggers it. Not necessarily, it could be something else, but that the baptism is this outward manifestation telling the world that I am a Christian and I'm going to follow this doctrine, right? You don't have a year from the date of your baptism. You need to do it ASAP, right?
That's correct. That's correct. And I've seen the circumstances where they waited too long. In that type of situation to file,
so they could have had the exception,
right? But if they don't file within a reasonable period of time, they lose that exception.
Yeah.
There's another category in the exceptions. It's called extraordinary circumstances, and these are factors that directly affect your ability to file for asylum. Okay. As I say, the burden of proof is on the applicant. You must show that the circumstances that came about were not intentionally created by the person or the applicant, either through action or inaction. All right. So if they can show factors that affected their ability to file for asylum, they would get an exception to the 1 year period. So a good example is if they get into a car accident toward the end of the 1 year period and they're hospitalized for several months, and that carries over beyond the 1 year period, they would have a reasonable period of time after the 1 year period has ended to be able to file for asylum and be considered timely based upon these extraordinary circumstances. Being involved in a car accident, death in the family.
Judge, what about mental health issues relating to their trauma, their persecution?
Yeah, certainly if you can show that post-traumatic stress disorder or any type of incident or a circumstance that affects your memory or your ability to recall, you would have a reasonable period of time from discovery that you needed to file an asylum application to do so. So let's say car accident again. You're medically traumatized and you have short-term memory loss. Eventually, it comes back. It may come back, months later. It may come back a half year later. But whenever it comes back and you realize that you have an asylum claim, you have a reasonable period of time after that. Post-traumatic stress disorder is a good one. If the person is suffering mentally, and or physically as a result of the persecution that happened to them in the past, and they're unable to function and go see a lawyer to fill out an asylum application, that could be an extraordinary circumstance where they would be given a reasonable period of time to file.
Judge, what if somebody just doesn't know about it? I mean, I know in communities people talk about it, and so a lot of people do know you have to file within 1 year, but is it possible that somebody might not know?
Well, that would depend upon the evidence that's shown to you as the adjudicator. And you would ask the question. You would, the government, I'm sure, would ask the question, and you as the immigration judge would ask the individual, well, why did you wait 18 months to file your asylum application after the expiration of the 1 year period? And based upon their explanation, just like based upon their claim of asylum, you have to determine their credibility. You have to determine their claim, whether it's reasonable. If the person says, "Oh, I just forgot," that's not that's not an exception. If they say, I didn't even know until I started getting my memory back, and they have medical documentation to show that they've suffered from short-term memory loss, then you have to make that adjudication. You have to make that determination whether it was within a reasonable period of time, given the circumstances of what happened to them or what is happening to them. I've even had
Let me give folks an example. We had a really interesting case where she was a Falun Gong practitioner, which is a philosophy and practice that's heavily banned in China. And one of her colleagues or fellow practitioners told her, you have to file on the 1-year mark. And so she thought about that, and then she actually met another practitioner who she accompanied him to the post office as he was filing on the 1-year mark. And so she just naturally thought that that's what she had to do. But then there were delays, but she brought witnesses, and the judge says, okay, hopefully next time you get a lawyer, when you file that thing. We weren't hired for the original filing. We got the court case, but she was able to get granted based on the judge's finding.
Yeah. That'll bring me to a topic that we're going to discuss later. But the question is, under extraordinary circumstances, you can file within a reasonable period of time. So what is a reasonable period of time? We talked about serious illness, mental or physical disability that prevents you from filing. You would have a reasonable period of time after that period of time, as we talked about, say, post-traumatic stress disorder or mental disability or physical disability or death in the family that prevents you from concentrating on what you need to do for your asylum application. There is legal disability that's specified in the regulations. And this is, let's say, somebody who's an unaccompanied minor who comes to the United States and doesn't file within the 1-year period. If they're under the age of 21, which is what the immigration authority says is the definition of a child, right? In the regulations, if they're under 21, they're under a legal disability, but they need to file within a reasonable period of time after they turn 21, right? They can't file at age 25 and say, I didn't know because I was a kid. They give you the exception, but it ends at the age of 21.
Judge, is there a ballpark as to what is reasonable? We know that 1 year is not. You don't have an additional year to file, but
there is a congressional intent that says 6 months, and I'll get to that particular how that falls within this 1-year exception too. A big one is ineffective assistance of counsel. If your lawyer gives you bad advice about the 1-year period, or if your lawyer fails to represent you in an effective way that protects your ability to file. For instance, he says, oh, you don't have to worry about it. You're in removal proceedings. We don't have to file until much later. Wrong advice, misadvice. Telling you, oh, you don't have to go to the proceedings because nothing's going to happen. And we'll get a later date for the merits of your case, whatever that merits hearing that'll be set up by the court. And you don't file within the 1-year period of time. Where the attorney is either given bad advice or no advice and fails to advise you of your obligation to file within the 1-year period of time, that could be a basis, a reasonable basis, an equitable basis, as determined by the courts, to be excused from the 1-year filing period and permit you to file within a reasonable period of time. Again, the question is, when do you discover that ineffective assistance of counsel? And was your filing within a reasonable period of time of that discovery? So usually that happens when you go to another attorney, immigration attorney, much more experienced, who advises you, hey, you missed the 1-year filing period. And the person says, but the person I had never told me that there was one.
Wow.
So, and it happens. It happens. Also, not everybody's schooled in immigration law. So if you go to, say, a law firm that specializes in personal injury, and they don't tell you about the 1-year period, and that attorney says, "Oh, don't worry about it. You can file for asylum," and you don't do it within the 1-year period, you go to immigration attorney and says, "Hey, I want to file for asylum," and he says, "You missed the 1-year deadline." Ineffective assistance of counsel.
Yeah. It's important to get somebody experienced, who does immigration every single day. There's too many nuances.
Always get a second opinion. That's what I say.
Yes, and always get a second opinion.
Yeah, just like in the medical field. Don't go under the knife unless you get a second opinion. Right.
Absolutely.
All right. So under ineffective assistance of counsel, there is a criteria. There is the matter of Lozada, which you talked about. There's case law that's been approved by both the Board of Immigration Appeals and by the various circuit courts. I think all of them do subscribe to it. Some have even modified it to a certain extent, but essentially the Lozada decision roadway in terms of making a claim of ineffective assistance of counsel. And that requires an affidavit, which outlines the agreement of representation and what was or wasn't done in the case. Did you advise the attorney of the allegations of this ineffective assistance counsel, and did they have an opportunity to respond? And did you file the complaint with the appropriate disciplinary committee so they can investigate? So as long as you follow that criteria, the courts will recognize as an equitable form of relief, which is kind of unique because equity doesn't really, that's a civil legal concept in equity, which we know the immigration law is a creature of statute, and there is no equity in there. But the courts have recognized where you're getting bad advice from a lawyer, we will give you that exception, and as long as you file within a reasonable period of time, we'll hear your asylum claim. So that's one of the other exceptions.
And notably, there's no requirement that you actually show the lawyer was punished by the Bar Association.
No.
Yeah.
No, there's no requirement that you have to show that the bar committee acted adversely against the attorney or that the courts have acted against it. Only that you follow providing the affidavit, providing the terms of the agreement of representation, providing that those allegations of ineffective assistance counsel to the attorney for them to respond, and filing a complaint with the appropriate disciplinary committee. Whether they take action or not, that's up to the disciplinary committee. But if you can show that the attorney failed to provide effective assistance of counsel in your case, the courts will recognize that as an equitable form of relief to excuse you from the 1-year filing period. Okay? Well, also, if you're in parole status, temporary protected status, any other immigrant or non-immigrant status, whenever that ends, you have a reasonable period of time. And what is that? I mentioned before, it's 6 months when that ends, as long as any of those categories are beyond the 1-year period.
Judge, we help a lot of students who are here and they're getting their bachelor's degree and they've been here for 4 years.
Right.
And a lot of them are concerned that, they passed the 1 year. What's your take on somebody who's been here on an F1 for 4 years?
Yeah, the courts have looked at the legislative intent, and it says 6 months is a reasonable period of time. But if you can show any of the other factors, any of the other exceptions, if you can show that they apply to you, then it's okay. But just for the ineffective assistance of counsel or the extraordinary circumstance, or in this case, You're talking about if you've been given a student status and you've been here for 4 years, then you waited more than 6 months to file. Legislatively, that's considered beyond a reasonable period of time.
So when does that period start counting? It starts counting when I lose my F1 status?
That's correct. So
Perfect.
let's say you have a F1 status that gives you 4 years presence here. You have 4 years and 6 months to file that asylum application.
Perfect. So advice to students is, hey, if you're coming up on graduation and you don't plan on getting a master's and you're afraid of returning, but you never applied because you had status, you should start preparing as soon as possible.
One of the things that you can do in that type of situation, if you're running up against the 1 year period, is under the regulations as students, you can apply for reinstatement for student status, or a continuation of your student status, or you can sign up for OPT, and that may extend your period of time to allow you to file within the reasonable period of time for your asylum application.
Here's a question, Judge, just for kicks. So let's say you have a student here from China, and 2 years into their stay here as a student, they began to be afraid of going back, whether it's religion or what was the reason. They never went back, but they continued studying and they never applied for asylum. But then, a few months before the graduation, let's say they graduated and they weren't aware of this law, but then they went on a cruise, to Mexico, and they came back while they still had status. Does the 1 year count from the last entry into the country from
the last entry? Yes, yes, it would. The last entry. That's what the statute provides. That's what the regulations provide. Last entry.
Yeah. Okay. Good to know.
There's also a situation where you may have filed within the 1 year period of time, but your application was rejected for one reason or another. And when they send it back to you, it's beyond the 1 year period of time. As long as you complete the corrections and get it back to them within a reasonable period of time, the service will consider that to be timely filed. Okay.
Perfect. And in that case, the reasonable probably isn't 6 months, or I'm not sure.
I would say, depending on what corrections they're looking for, some may be very complicated, some may be very easy. So that would depend on the circumstances.
Case by case.
Yeah, of course. And then death or serious illness or incapacity of the legal representative would extend your period of time. That would be considered an extraordinary circumstance and excuse your 1 year filing deadline, but you must file within a reasonable period of time from discovery. All right. So that's a lot.
Yes.
That's a lot there are a lot of exceptions or interpretations to the exceptions that could apply in your case. I always recommend consult with an immigration expert. This primarily is to give you an idea of what exists and what can apply in your particular case. But for those people that are up against this particular issue and that want to know more, I would recommend that they consult with an immigration expert.
Absolutely. In these cases, even the slightest mistake sometimes can really affect you, and it can be very hard for your next attorney to fix it. So, right from the get-go, start consulting with folks, get that second opinion, like Judge said, and hopefully, the information in this video will help you make the right decisions.
Right. One other thing I just want to mention, which I'm not going to cover in depth substantively, but there is no time limit to filing a claim for withholding of removal or relief under the Convention Against Torture. But that's a whole different kettle of fish and a whole different substantive topic that we can discuss in the future. But there is no time limit with regard to those filings. Okay.
Judge, let me throw an interesting situation at you. So we have a good number of immigration agents or notarios out there, and some of them well known in the Chinese community. They've been giving people the following advice. As we know, especially after COVID, getting an interview at the asylum office is really just
difficult.
it's difficult, man. We don't know when it's going to happen. And when last in, first out was introduced in 2018, you have people who apply before that, they're stuck. So we have clients who've been waiting for a very long time. So you have these agents that say, you know what? You could write a letter to USCIS and you can ask them, to, just refer your case or you withdraw your case. That's what they say. Ask to withdraw your case, okay? And when that happens, a lot of times USCIS will issue an NTA. But you ask to withdraw the case, and now the case lands in court.
Right.
That can be a problem for the 1 year because you withdrew it, didn't you?
Yeah. That was an interesting discussion we had in the office this week, where the individual withdrew their application to seek relief based upon a family-based petition through a spouse. But that marriage turned sour. And before that, the individual withdrew their asylum application because of the prospect that they were going to receive their status through marriage, family-based. But now that the marriage is sour and the parties are contemplating divorce, the government issued a new NTA.
Oh.
And in so doing so, the big question is, can they revive their asylum application? Once they withdrew it, it's considered withdrawn, no longer pending. Yeah. And does that start the clock again for the? Does that nullify the period of time that they have had to file that, and their 1 year period has expired?
I like their chances better than the ones that the agents are having completely withdraw just for the reason of getting, gaming the system. At least there's an argument there.
Right. There is a legal argument to that one. But where the let's say the non-legal representative advised that advise you in terms of withdrawing, can you claim ineffective assistance of legal counsel? The argument there is maybe, but not probable.
And they're not counsel. Yeah,
they're not legal. They're not attorneys. They're not disciplined by the bar committee, which is one of the facets of the Lazada, that you file your complaint with them. But can you claim fraud and material misrepresentation? And therefore, it's an extraordinary circumstance. You were hoodwinked into thinking that they had that they were representing you in the same regard as an attorney would be representing you. If you believe that, there's an argument. But as I say, the probable outcome is the immigration court, and I would have ruled that that wasn't sufficient. That you need to show that it was a legal representative, someone who was admitted to the bar, that made this recommendation to you, and you accepting the advice of a layperson or somebody who holds themselves out to be an immigration expert. That becomes something that's not recognized in the Immigration Nationality Act as an exceptional circumstance. So
I really appreciate you answering that, because not only do they tell their clients this, some of them have, WeChat groups and Telegram groups and even YouTube channels, and they'll say this stuff, and then the person can't even claim, "Oh, he advised me personally, but I follow him and he has a good reputation, and so I did it." Horrible for the clients. Horrible. It
is. And as I said before, get a second opinion. Always get a second opinion on that.
Go see a lawyer.
Yeah, go see. Well, the problem is on the notarios. They, like in Mexico, they hold themselves out to be legal representatives. So people believe that they do have legal authority like an attorney.
Yeah.
they have a certain esteem in the legal community as being, you know, a notario, being a legal representative. So it may be hard for the applicant, but if they can explain what their circumstances are and why they believe the person was legally representing them, as I say, there's a possibility, case by case.
Case
So,
by case. Yeah.
Yep.
Have to prove you really believe that. So,
right.
yeah.
But consult with an expert, immigration expert, and get the advice of what your rights and obligations are. Certainly.
That's it.
Yeah. So this is just one segment of the asylum, just filing the application and the requirements to do it within 1 year and what those exceptions are. So I think for the next podcast, we can cover another topic, or we can continue on with the asylum. I'll leave that up to you.
Okay, guys, and let us know what you think based on your opinion. We'll make the next video. But Judge Hom, thank you so much for sharing your wealth of knowledge, and this is really important for clients that follow us to be able to access this.
Yeah, let me suggest this to our listeners. If they do have a question that they need to be answered, if they email me at alex@alexanderlaw.com, I'll try and get back to you.
That's great. I'll put it on the comment section and on the channel. That'd be very grateful.
Okay. All right. So I think that'll be the wrap up for this session of the podcast. But hopefully we'll continue later in the very near future.
Let's do it. So tune in for the next episode, and we'll see you next time. Take care, guys.
Okay. Bye-bye.
Bye-bye.